Welcome, everyone. I'm Richard Scheffler, and I'm the director of the Petris Center in the School of Public Health at UC Berkeley. The Petris Center was established in 1999 through an endowment from the California Attorney General's office and named after a former state senator, Nicholas Petris. The mission of the Petris Center is research that focuses on consumer protection, affordability, access to health care, especially for low and middle income populations. Our research also focuses on the role of information to the consumer, regulation, and competition in healthcare markets. So I'm welcoming here today to the second conference we've had on accountable care organizations. It's actually a workshop. This year's workshop is different than the one we did last year. The workshop last year focused on assessing the performance of accountable care organizations, looking at cost, quality, and market power. The results of that conference and the papers that were delivered are forthcoming in a special issue of the Journal of Health Policy, Politics, and Law. I checked my email last night to see if I could give you a copy of it, but alas, it's not quite ready. These things always take longer than you think, but it should be online in just a few weeks, and we'll send that issue on to you when it appears. Today's workshop focuses on the regulatory implications of the rapid growth of ACOs nationwide and especially in California. While ACOs have been growing fast around the country, here in California we've seen particularly dramatic increases in the number of ACOs and the number of lives covered. Just 3 years ago there were 30 ACOs in our state. Today there are over 100 that cover over 1.5 million lives. At the Petris Center, we believe this dramatic growth provides both a challenge and an opportunity for state regulators. In California and beyond, we have become interested in the role of state governments can play in ACO innovation while still protecting the public from potential risk. Using the experience from other states that have already pursued regulatory approaches, in particular states like Rhode Island, New York, Massachusetts, and Texas, we hope to draw on the lessons from these states to put in place a balanced approach in California. The experience of these states and the lessons from other states is the topic of the first panel, chaired by Kathleen Foote. To that end, we're excited to hear from a group of policymakers and practitioners from these 4 states who have direct experience designing and implementing these emerging regulations. After a break, our second panel, chaired by Emilio Varani, will dive deeper into the regulatory implications of ACO's potential anti-competitive behavior. This panel will discuss specific legal implications drawing from the experience and knowledge of many attorneys in this room to complement the policy perspective. This is followed by a keynote by our keynote speaker, Lawrence Baker from Stanford, who will talk about physicians and hospital integration. Finally, at the end of the day, panel 3, will be chaired by my colleague and friend Steve Shortell, will delve into the implications of financial and clinical integration. This panel arrays expertise from economists to policy experts who will speak on the implications of integrations for quality of healthcare and cost. I'm also very pleased to announce that Chris Kohler, the president of the Milbank Fund, has agreed to co-publish a report in the Milbank Journal based on the work of the Petris Center, the background papers that you've seen, and the discussions that will happen at this meeting, which will be summarized by the staff. And I talked with Chris, and we're going to try to fast-track this and get it out in early September. Of course, any remarks you make or any time we quote you in any particular way, you'll be seeing the exact thing that we say about you or what you said. So I think those are my opening remarks. I think you can tell by the TV camera that it's being filmed. I hope that all of you have, I think all of you have signed the releases. And so be aware that you're on camera. If you make a mistake and you want something expunged afterwards, just let Katie know and we will take care of that. So with no further ado, I'd like to turn the panel over to Kathleen Foote, Senior Assistant Attorney General in the Antitrust Division in California, and also a board member of the Petris Center. Thank you, Kathleen.
Thanks, Richard, and good morning, everyone. It's really a pleasure to be here again. There have been some very, very interesting dialogues that have been coming out of the studies on ACOs through Petris, and I'm looking forward to this one today. We're beginning with kind of the lay of the land here with people from several states describing alternative regulatory approaches to ACOs in very different competitive landscapes. Some places that have that are characterized by market power on the insurance side, others characterized by market power on the provider side. Different things happening, and different, essentially different regulatory histories as well. So just getting a sense of the kinds of choices that are being made, as well as the successes and failures of the alternative approaches. Even though it's still fairly early, I think it's going to be a really great way to begin the program. There are going to be 5 panelists, followed by a commentator. And first is going to be my counterpart, Kim Van Winkle, who's the head of the Antitrust Bureau in the Texas Attorney General's office. Then Katherine Mills will describe Massachusetts. She's the acting policy director for market performance in the Massachusetts Health Policy Commission. Then we'll shift to Rhode Island, and Herb Olson, the legal counsel for the Health Insurance Commissioner, will describe that. Then we'll move to New York. A very different approach. And James Knickman, who's the Chief Executive Officer of the New York State Health Foundation, will tell us about that. And finally, we will come back to California, and Ann Hollingshead from the Petris Center itself will review the landscape in California for us. Finally, we'll hear from Greg Burke, the Director of Innovation Strategies for the United Hospital Fund in New York City, is going to pull it all together for us. So let's begin. We'll do one at a time, but then then everyone is going to sit down at this panel. So let's begin with Kim.
Good morning, everybody. Thanks for having me. I'm excited to hear everyone's remarks today and hopefully learn some new things. Kim Van Winkle from the Texas Attorney General's office, and I'm going to talk about the healthcare collaborative legislation that the Texas legislature passed in 2011. It arose out of a desire to encourage more coordination of care, to promote innovation, and there was a lot of input from the various stakeholder groups throughout the legislative process and the rulemaking process. So I think you'll get a sense of what went into this as I describe this legislation to you. So the Texas Healthcare Collaborative statute can be found in Chapter 848 of the Insurance Code. The goals that the legislature identified were to encourage collaboration and innovation in healthcare delivery and payment models. It sets up a structure in which the Texas Department of Insurance can grant licenses to healthcare collaboratives to operate as a unified provider network in Texas. And the Office of the Attorney General is tasked with doing the antitrust analysis, essentially, which I'll explain in more detail later. So we've collaborated closely with the Department of Insurance throughout the legislative and rulemaking process, and it's been a pretty smooth process to work together on this. They are sort of coming at it from an insurance regulatory standpoint, thinking about things like solvency and network adequacy and traditional insurance regulatory issues that can arise when you're looking at healthcare collaboratives. And since we have some antitrust expertise, we were given the role of trying to ensure that granting healthcare collaborative licenses will not permit the exercise of market power in a manner that could actually have a net negative impact on consumers. And lastly, I should mention that the statute does specify that the state cannot authorize any conduct that would be otherwise a per se violation of the antitrust laws, which is to say this healthcare collaborative licensing process is not about authorizing naked price fixing, which for those of you who aren't antitrust lawyers, it means there has to be some genuine efficiency associated with what the collaborative is proposing to do, and not just immunize them from antitrust laws for the purpose of doing them a favor. And I guess I should have added that the granting of a healthcare collaborative license is intended to confer state action immunity from the antitrust laws for the subsequent conduct of the healthcare collaborative. So the bill that established healthcare collaboratives in Texas also created an entity called the Texas Institute of Healthcare Quality and Efficiency. This institute is sort of a think tank that is looking at big picture standards that we should apply when we're reviewing healthcare collaborative proposals. They were tasked with making recommendations and identifying and promoting evidence-based approaches to improving quality of care and containing costs. And I think there was specific mention of reducing the incidence of preventable events. I do think the legislature is focused specifically on hospital readmissions, for example, as something that people recognize we can make improvements on. And they're also tasked with evaluating different value-based payment models and delivery systems and trying to identify best practices in this area and potentially establishing standards to be applied to healthcare collaboratives. And the Institute has been active. You can look on their website, it's ihcque.org. They have a 2014 report to the legislature that makes some recommendations, including expanding access to care for people who could have Medicaid eligibility. And they also focus on some specific issues, such as serious persistent mental illness as being an area where improvements in the delivery of care could yield significant savings and improvements in quality. They focus on things such as data sharing, obstacles that state agencies that they themselves encountered in trying to do their work. They realized we can't even collect the data easily from all the state agencies, much less combine them into one database so that we can ascertain accurately what's going on. So they've asked the legislature to consider trying to reduce some of the barriers to data sharing. And they also made some recommendations about Medicaid managed care to encourage the legislature to facilitate more pilot projects focused on shared savings, episode-based payments, and centers of excellence as areas where pilot projects might yield some useful new concepts. So back to healthcare collaborative licensing process. In 2013, the Department of Insurance adopted rules. It did take over a year. Like I said, there were lots of opportunities for all affected parties to provide input into how this should work, and it made it not an especially fast process, but I think that everyone was, I shouldn't say that. I think, were satisfied with the rules that we ended up adopting. And those can be found at 28 Texas Administrative Code, Chapter 13. The statute provides that the AG's office should do the antitrust analysis and then make a recommendation to the Department of Insurance, and it's only if the Attorney General's office says this passes muster on our antitrust review that the insurance department can grant a license. So even though the Department of Insurance is the regulator that grants certificates of authority, they can't do it unless we green light it. The application for a certificate of authority has to include some basic information and identify their service area, establish that they have an adequate network of providers to cover that area. They have to identify the population that they're serving. And then once the application is received, there's a 190-day clock to approve it. The application has a second tier of information that has to be provided in the case of a healthcare collaborative that has over 30% market share in any primary service area where there are two or more providers in competition with each other. So that's one thing that we wrestled with in approaching this from the beginning. Is a collaborative is by definition a compilation of hospitals, physicians in different specialties, all different kinds of providers potentially, and any one of those may have market power in their specific market. And there was a notion that the application shouldn't be burdensome in general. For some healthcare collaborators, might be fairly easy to analyze and decide that they don't pose any real risks. But if there's a market share, if you have two or more providers of the same service, then there's this 35% market share screen, after which you have to provide a lot more information about who your payers are, what percentage of your revenues are coming from them, who your competitors are, and your market shares, your pricing information. It's a much more thorough process if there's a potential market power element to it. The application requires $10,000 fee initially, and then it has to be renewed annually, and it's $5,000 for renewals. And then the rules also provide that the Department of Insurance can make a supplemental assessment. Like the legislature indicated that all the costs of the program have to be paid through the fees, and so if these standard fees don't cover all the costs, then there might be a supplemental assessment to make sure all the costs are covered. So the most interesting part, I guess, the approval standards set forth in the statute. The healthcare collaborative must demonstrate a willingness and potential ability to provide healthcare services in a manner that increases collaboration, integrates healthcare services, reduces the occurrence of potentially preventable events, contains healthcare costs without jeopardizing quality, and compiles, evaluates, and reports statistics on performance measures and utilization patterns. So, this is really the meat of this regulatory scheme. And then the last one is sort of more of an insurance regulation issue. They have to establish that the network can be solvent, and I think this is mainly a concern when there's capitation or extreme financial risk sharing involved. I wanted to mention one aspect of the rules that elaborates on this. Section 13.481 of the rules talks about the quality improvement and structure for the collaborative to establish. They have to have a quality improvement committee, and the committee has to establish policies and processes to promote evidence-based medicine, coordination of care, and they have to measure and report the quality of the healthcare services and the impact of costs. And it goes into some detail as to the measurements and reports that they have to provide. So before I move on, I think one of the challenges in trying to set up this kind of regulatory scheme is most of these collaboratives would be de novo entities that didn't exist before. And so these are all prospective plans, and it might be hard for them to provide the level of detail that we want to see to be assured that they're conforming to the statutory and regulatory requirements. And then once the state approves the collaborative, how much wiggle room is there for the plans that they put forth in their application to change? And in order for the antitrust immunity to be established, the state has to really closely track what's going on with this collaborative. The state can't just license the collaborative based on their proposal and then let them go off and do whatever they want. And so the rules are filled with requirements of reporting any changes to the participating providers, the service area, the payment models, whatever plans they laid out. If they change, the state has to review those changes if they're significant in any way. Next is this is the aspect of the approval standard that the Attorney General's office is responsible for. This is really the antitrust analysis. And it's found in Insurance Code section 848.057. We have to make a finding in order for this collaborative to get a certificate of authority. We have to find that the collaborative is not likely to reduce competition in any market for physician, hospital, or ancillary healthcare services due either to the size of the collaborative or the composition of the collaborative, and this part's important, including the distribution of physicians by specialty within the collaborative in relation to the number of providers in that geographic market. And so what this really means is, we want to look at how many heart surgeons are in this network. We want to look at how many primary care physicians are in this market, how many specialty hospitals are in this market. And the market power analysis can really be granular to any component of the collaborative, because I think the concern is that if you have market power in hospital services, and all of the physician providers that are participating in your collaborative don't have any market power, well, perhaps the hospital could leverage its power to increase prices for all the participating providers. And traditionally in antitrust analysis, there's a fairly granular look at each specialty, each type of service, and you want to ensure that it all remains competitive and that the combination of them is not going to facilitate market power that could benefit all of them. So then the balancing test is we have to determine that the pro-competitive benefits of the proposed collaboratives are likely to substantially outweigh the anti-competitive effects of any increase in market power. The rules state that test will be done in accordance with established antitrust principles, so applicants could do some research and sort of predict what kinds of efficiencies will be cognizable in this balancing approach and how this balancing test might come out, because there's a lot of authority available in antitrust law for trying to measure pro-competitive benefits and anti-competitive effects. It's not always easy, it's not always possible, but at least there's a rich set of guidance out there for how this would be undertaken. And then lastly, and very importantly, the statute says that we will consider what CMS has done, what the FTC and DOJ have done, if they have reviewed this same group under the ACO regulations. That's to be given weight, and I think that's important for applicants. I think it's a signal that there should be some consistency, if not total consistency, between what the state is doing and what the federal regulators are doing. And then one more point, the Section 13.441 of the insurance code has another market power screen. It prohibits a healthcare collaborative that includes a dominant provider from using any exclusivity provisions in their contracts. And a dominant provider is defined as a provider with greater than 50% market share in its primary service area. And the primary service area is the smallest number of zip codes from which at least 75% of its patients are drawn. So there's sort of a formula laid out for determining whether a proposed collaborative includes any dominant providers, and if so, they can't, if they get a certificate of authority and they're negotiating contracts with payers, they can't make it such that it's exclusive for the participating providers. The providers have to be free to contract independently of the group, and there can't be exclusivity with respect to that payer and that collaborative. Just touched briefly on the state action immunity doctrine. I mean, this really was the idea, I think, underlying the passage of this legislation, is that there might be instances where a group wants to function as a collaborative and they've got some antitrust concerns. That doesn't necessarily mean that it's an anti-competitive scheme or that they're trying to get away with something that wouldn't pass muster under the federal antitrust laws. I think just the risk of liability is enough to thwart some pro-competitive activity that might be contemplated. And so the statute and the rules were designed to satisfy the Supreme Court standards for state action immunity. Federal antitrust law requires that in order for the state to trump federal antitrust law, the state has to clearly articulate a policy to displace competition with regulation and actively supervise the conduct. And active supervision really is substantive review of the merits of each anti-competitive act or agreement. And again, this comes back to, this was a difficult concept, I think, for the stakeholders during this process. Like, they're like, give us our certificate of authority and then we're off to go do our thing. And it's not that way. It just doesn't work that way. They're just exposing themselves to antitrust liability if they do that. They really have to tell the state what they're going to do, and then if they deviate from that, the state is going to have to oversee that and approve that. And yeah, you can see the standard is whether the state has really made it its own act and not just something that the collaborative participants are doing independently. As the state is undertaking to actively supervise the collaboratives, part of the approval process, like I mentioned, is there are some market power screens built in. The statute itself says the proposed collaborative can't be likely to reduce competition in any market for provider services. That's part of the OAG's, the Attorney General's review, antitrust review of the collaborative. That kind of, I think I mentioned this, that kind of analysis conforms to antitrust law. It's something that's familiar to antitrust law because it's the sort of analysis we do when we're looking at proposed provider mergers in terms of defining the market and identifying who competes and whether there's likely to be market power. I made a note that the FTC has stated that in different various contexts over the years that the antitrust laws already permit pro-competitive collaboration among competing providers, so there really is no need for states to confer state action immunity in a case where a collaborative is functioning in a pro-competitive manner. Well, like I said, I think the dissonance comes when the providers say, well, we're not sure, and our lawyers can't tell us that we're sure that this is going to pass muster, so we can't really move forward unless we've got some certainty. I think it's interesting, last month, the FTC wrote a letter to, I don't want to speak for New York, to the New York State Department of Health, and all I saw was that there were these performing provider systems under the Medicaid DSRIP program seeking certificates of public accommodation, and the FTC wrote and said, this is really unnecessary because if this is a good thing, it's already legal.
I'll go into that in more detail.
Great. I'm interested in that. And then lastly, just as an element of active supervision, the rules include a provision in section 13.416 that the Department of Insurance can impose restrictions on the certificate of authority. For example, they could say, we're granting your certificate, but you can't have any exclusives in your contract. And that, I think, could be above and beyond the exclusives that are prohibited by the statute. The Department of Insurance could condition the approval on no use of most favored nations clauses. They could require specific transparency provisions or restrict the geographic area or the types of services that can be included. And that's just a way of maintaining state control over the collaborative's activities. And then lastly, the state action immunity doctrine really requires that the state exercise ongoing supervision of collaboratives. And so, like I mentioned, it has to be reviewed and reapproved each year. They have to report any material changes in what they're doing or how they're comprised. And we have pretty broad authority at any time to come in and say, show us your books and records. And that's all in order to solidify the likelihood that they'd be found to be immune. Thanks.
Good morning. My name is Kate Scarborough-Mills. I'm the Acting Director for Market Performance for the Massachusetts Health Policy Commission, and I'm really excited to tell you about what we've been doing in this space. And I know we're going to focus primarily on ACOs today, but the work that Massachusetts has been doing in the ACO space is actually really very interconnected with our greater efforts around increasing both innovation and accountability in care delivery, in payment structures, and in market performance. And so I want to kind of start with that slightly higher level. As I'm sure you know, Massachusetts has a kind of long history of significant healthcare reforms trying to achieve better health, better care for the whole population, dating back over 20 years, and including the 2006 Universal Coverage Bill, which became the model for a large part of the ACA. The 2012 legislation, Chapter 224 of the Acts of 2012, was really what we've called the second stage in healthcare reform. That bill implemented reforms across a spectrum of healthcare topics to try to create a sustainable rate of growth for total healthcare expenditures tied to the economic growth of the state as a whole. It made substantial investments in community hospitals, in the primary care workforce. It included significant provisions around price and market transparency. It required the state to develop standards for patient-centered medical homes and ACOs. It set goals for the adoption of alternative payment methodologies in the state. And it created a new independent state agency, the Health Policy Commission, which I'm here representing, and which is chaired by Stuart Altman, who I know many of you know well. The Health Policy Commission has a broad charge to implement much of the legislation and to develop health policy to reduce overall cost growth in line with the healthcare cost growth benchmark, while improving the quality of care and monitoring healthcare delivery and payment systems in the state. And I'll note that I did say that we are an independent state agency. Just to clarify what that means, we are governed by a board of directors. We have 11 board members. We are within the executive branch, but that board is actually appointed by 3 separate constitutional officers, so we are not actually under the sole control of the governor. All of the pieces of that legislation, Chapter 224, really center around 4 key themes laid out here. First, promoting an efficient, high-quality healthcare delivery system, including through ACOs. Second, advancing alternative payment methods that support and equitably reward providers for delivering high-quality care while holding them accountable for slowing the overall growth in healthcare expenditures. Third, developing and supporting a value-based market in which payers and providers openly compete to provide services. And relatedly, engaging consumers and employers by enhancing access to appropriate information and creating the incentives to allow them to make high-value choices for their care and coverage options. The Health Policy Commission is the key state agency in charge of implementing those goals. And we do that through an array of activities, some of which I've summarized here. But acknowledging that we're here primarily to talk about ACOs, I really want to highlight 3 of them that are most related to care delivery innovation. Our Registration of Provider Organizations program, our authority to review material changes to the operations and governance structure of provider organizations and conduct what are called cost and market impact reviews, and our certification program for ACOs. So first, our Registration of Provider Organizations program. Under the Registration of Provider Organizations program, all provider organizations over a certain size and all providers who take on downside risk, so by and large, all ACOs, must provide certain information to the Health Policy Commission and other state agencies on an annual or biannual basis. For example, we get uniform data on provider organizations' corporate, clinical, and contracting relationships, financial condition, and affiliated providers. Providers who take on downside risk, such as ACOs, also have to go through a process with the state's Division of Insurance to get what's called a risk certificate. That is actually primarily certifying that they have the financial capability to sustainably take on that risk. All of the information collected by these programs is public, and it's designed to be linkable to provide a basis for ongoing evaluation of the market by researchers, by government, and by market participants. The HPC also encourages a value-driven marketplace by examining significant market changes, such as the creation of ACOs, as well as mergers and acquisitions and other types of new contracting and clinical affiliations between providers. Recognizing that these types of changes can impact healthcare system performance and total medical spending, either positively or negatively, providers have to provide 60-day notice to the Health Policy Commission before engaging in these types of transactions. We then have 30 days to do a preliminary analysis, and for transactions that are anticipated to have a significant impact on healthcare spending or on the competitive marketplace, we can undertake a 6-month review called a cost and market impact review, which includes time for the providers under review to respond to the HPC's findings. The result of the cost and market impact review is a public report, and the transactions may not be finalized until that report has been issued. Where appropriate, our reports can also identify areas for further review or monitoring, or be referred to other state agencies or the state's Attorney General's office to support their work on behalf of healthcare consumers. And I'll note that, to our knowledge, this is the first time that any state has authorized such a prospective, public policy-oriented review of healthcare market changes that is really pretty distinct from antitrust and law enforcement review, as well as distinct from administrative determination of need or certificate of need type review. Cost and market impact reviews, rather, are a response to the acknowledgement that provider alignments both offer opportunities to promote more efficient, coordinated care, but also pose risks of increased market concentration, increased prices, or changes to referral patterns that can increase healthcare spending. These reviews allow us to examine such changes rigorously based on the individual facts of a given transaction, to promote transparency and accountability, and to encourage those positive outcomes while minimizing any negative impacts. So what do we look at in our reviews? This slide lays out the statutory factors for cost and market impact reviews and our review of material changes to provider organizations. Broadly, these can all be categorized as factors related to healthcare costs, quality, access, and other factors in the public interest, which all really pertain to healthcare market functioning. And you'll see that in our published reports, which are all available on our website, I urge you to read them, we do conduct analyses across the spectrum of all of these dimensions, looking both at the performance of providers coming into the transaction and what the anticipated performance will be post-transaction. We examine the factors by analyzing the terms of the transaction itself, our knowledge and data regarding the broader Massachusetts marketplace, and ongoing interchange with the parties, including the ability to receive confidential data and documents from the parties and from other providers and payers in the marketplace. This slide lists out some of the types of questions we ask using each of those types of information. I also wanted to give you a sense of how many of these types of reviews we've done so far. Since April 2013, when our process began, we've received notices of 38 provider transactions, with changes related to physicians topping the list in frequency. I'll highlight that the fourth category here, formation of a contracting entity, is where formation of a new ACO would fall. 3 of the 5 listed there are formation of a new ACO. And I'll also note that in the first 2 categories, physician group network affiliation and acute hospital network affiliation, a subset of those are actually physicians joining an existing ACO or hospitals joining an existing ACO. In each category, about 3 or 4 of them. We've also issued cost and market impact reviews on 4 transactions to date. Leahy Health System's acquisition of Winchester Hospital, in which we found a potential for cost savings and care delivery and access improvements, coupled with some concerns about increased market competition, or increased market leverage, rather, as well as 3 transactions involving expansion of the largest provider system in the state, Partners Healthcare. For those 3 transactions, Partners proposed acquisitions of Harbor Medical Associates, South Shore Hospital, and Hallmark Health System. We found that increases in spending would be anticipated on the order of $38.5 to $49 million per year for the top 3 commercial insurers. That did not include any increases in prices due to increased market leverage. We did not anticipate that potential savings from decreased utilization through care delivery reforms or population health management would offset those increases. We ultimately referred those reports to the Attorney General, and as a state court was reviewing the proposed settlement between the Attorney General and Partners, we also sent our reports and additional analysis to the court to aid in that review. As many of you know, ultimately that settlement was rejected, and Partners abandoned its bid to acquire South Shore Hospital. Although Partners moved forward with its acquisition of Harbor Medical Associates, it did so by committing not to increase contracted prices for those physicians beyond inflation for the next 5 years. And I'll note that the Hallmark transaction is still pending. Returning to the topic of ACOs, though, I'll note that while the HPC has not yet conducted a cost and market impact review on formation of an ACO or providers joining an existing ACO, we have the same authority there to review those changes, and if we anticipate a significant impact on costs or market functioning, do a similar type of review. Finally, the newest work of the Health Policy Commission in the ACO arena is our ACO Certification program. Under Chapter 224, we're required to create a certification program for ACOs, and we anticipate releasing those standards in the form of regulations later this year. So they're still under development. And for that reason, there's a little bit less that I can share here, but I'll give you some key points. First, ACO certification in Massachusetts is envisioned to be voluntary. ACOs participating in public payer or commercial contracts are eligible for certification, and ACOs which choose to participate will get a seal of approval from the state, as well as preferential state contracting. We're also actively trying to explore means of giving technical assistance. Second, ACO certification standards are required to be updated at least every 2 years. We anticipate that for the initial certification period, many of the criteria are likely to be capability-based and consistent with standards in CMS and commercial contracts, with the potential for a few enhancements. However, we anticipate requiring quality and other reporting from certified ACOs, and as that data comes in, it's a priority for us to include additional quality measures and outcome measures in particular in future cycles of certification. Third, I want to emphasize that ACO certification in Massachusetts does not include any change to existing laws relating to market competition. In other words, ACOs in Massachusetts are subject to all existing state and federal antitrust law, as well as the material change notice and cost and market impact review process that I highlighted before. Fourth, while the statute sets out some minimum standards for ACOs, it also gives us a very broad charge, setting forth 3 broad goals and 15 related sub-goals that you see broken out here. Balancing our twin values of promoting innovation and accountability, we plan not to have an overly prescriptive program that defines each of these programmatically in depth up front, but to require reporting along the key dimensions relating to these goals so that we can refine further certification standards as we continue to drive toward better health and better care at a lower cost across the Commonwealth. Thank you, and I realize I went through a lot of that pretty quickly, so feel free, if you don't have time to ask me questions while we're up afterwards, feel free to grab me throughout the day, and I'm happy to talk about any of the work that the HPC has been doing.
Good morning. My name is Herb Olson. I'm the legal counsel with the Rhode Island Office of the Health Insurance Commissioner. Small bridge, not quite as big as California's wonderful landmark, but then, you know what? Rhode Island is, I'm going to go to, Rhode Island is really small. You know, and that's not even the scale. You know, I think you'd have to make it even smaller. It takes all of about an hour and a half. It takes no more than about an hour and a half to get from any one point in the state to another. So,
Except on Friday in summertime.
What's that?
Except on Friday.
Except if you're going to the beaches in the summer, that's right, and if you have to go through Providence during rush hour. Just back a little bit about the office. I think we're the only agency in the country whose sole job, you know, their only job is to regulate health insurance and promote affordability. It's a kind of a quirk of some things that were going on locally, politically, in around 2004, 2005, and this was created. I usually don't think too much of reorganization as a way to accomplish things, but in this case, I think it was very helpful to have a focus, particularly on health insurance. What I'm going to do, I'm going to go and we are going to get to ACOs, but I think I need to talk about it in the context of what we're trying to do with our affordability standards. Our affordability standards are really the key function, not key, it overarching, I think, function of the office. We'll try to put ACO development into the context of our affordability standards and how we view ACOs. And finally, I want to talk a little bit about the implications for what Rhode Island is trying to do for other states that might have very, very different you know, healthcare environment or regulatory environment or political environment. Yes, we are very small. So that means we have actually, so we're comprised of a commissioner. We have a couple of sports staff. We have 7 professional staff, 2 of which are devoted to the affordability standards, the others traditional, you know, kind of insurance regulatory functions. And we have 2 great consulting actuaries, but they're mostly involved in our annual rate review process. So we are small, and that governs to a certain extent how we try to tailor our programs, our regulatory programs. We just need to take into account we don't have many people to do the work. The other key element, I think, is that we have a very fragmented payer market. I don't think that's all that different maybe from a number of states, but I think it's worth mentioning in terms of what we're trying to do in terms of affordability and how we take a look at ACOs and how we've chosen to address some of the risks of ACOs. Now, that 50% number, you need to understand, is both self-insured and insured. And the split in Rhode Island, you know, frankly, it's growing more and more self-insured. I think it's anywhere between 65%. So effectively, if you look at all the covered lives in Rhode Island, our office regulates about 17 or 18% of the covered lives in Rhode Island. So the challenge for us is to use that and try to promote system change. Quite a daunting task, but so far we've been able to, I think, been able to leverage that fairly narrow jurisdiction to push system change. Now, in terms of the healthcare environment in general, I think the first key point is that we have a couple of very dominant hospital systems. We did a study a couple of years ago. I sort of call them duh statements, right? Substantial variation in payments for Rhode Island hospitals that are offering similar care, son of a gun. And commercial insurers tend to pay more, sometimes significantly more, to the two dominant hospital systems than to hospitals with less negotiating leverage. I love the way researchers say these things. It's wonderful. Now, that has implications, obviously, for how we want to deal with ACOs, because ACOs are a concentration of providers, and we're looking at what's happened in terms of hospitals and looking to a context where we're potentially going to promote ACOs, and you got to beware. You know, those are some lessons to be learned, and you need to be able to address the potential harm, negative outcomes that could occur from increased concentration. However, we firmly believe that the development of ACOs is absolutely critical to our mission to promote affordability. It's the vehicle, it's the structure that is available to us right now to get into population-based contracting, integrated systems of care, and finally, accountability for cost and quality. We have some basic principles that guide what we do. The first one, I think, is maybe the most important. We hold health insurers accountable they must be made responsible for the long-term cost implications of how they're acting in the marketplace. That it can't just all be about annual health insurance premiums. You just get so frustrated dealing with you need to do that. You need to make sure that all the assumptions that are made in the filing are accurate and all that. But if you're just doing that, we don't believe that a health insurance company is merely a helpless pass-through for health insurance costs. The other thing, a lot of these standards came about from discussions between our former commissioner and some of the carriers. The commissioner would say, geez, this is ridiculous. This is going up and up, and what can we do to change this, the prospects in terms of rate increases, in terms of affordability? And one of the things that the carriers said, hey, we're getting killed on our negotiations with hospitals and other providers, especially hospitals, in terms of reimbursement contracts. Again, fragmented market. You have commercial payers representing, 17, 18% of covered lives coming to the hospitals who already have some near monopoly segments covered. Maternity care. Virtually all of maternity care in Rhode Island is provided through one hospital system. Imagine the sort of full-page ad you can do during a negotiating session over that fact. So basically what we're trying to do, we think carriers have obligations, but we also recognize that a bit of thumb on the scale is helpful for them when they're sitting down with providers and trying to negotiate that next contract. We do this through a concept of regulatory leverage. As Rhode Island has a pretty strong rate approval process, prior approval. We've also organized our review through an annual all-payer, all-market review process. So we get all the rates all together, get all the carriers all together, review them all at once. When we get around to approving rates, usually lower, it's just the way that game is played. The approval is going to be subject to conditions requiring a carrier compliance with system reform activities. The conditions definitely include standards for reimbursement contracts, and by that mechanism, we're hoping, I think we have influenced pricing trends and provider behavior. I'll go through some of the components here. Won't spend too long on some of them. We'll try to get to the payment reform matters, but a couple of things I think are interesting. For some time, when the affordability standards were first implemented back in about 2008, one of the primary focuses was built on the observation that primary care was kind of getting the short end of the stick in terms of reimbursement, in terms of the overall allocation of a carrier's medical spend. And we made a conscious effort to say you got to increase that, and not just so that primary care docs are great people and you want to provide them more money, but from a policy perspective, you want to create an infrastructure where if you believe that primary care is really essential for care transformation and payment reform, well, then you need to be able to give those primary care practices the wherewithal to be able to do that, to play that role. The other aspect, let's see, and we carries to support some administrative expenses of our medical home initiative, health information exchange. Care transformation is also part of that. Pretty strong patient-centered medical home model ongoing for a little while. A lot of people will say, well, patient-centered medical homes just can't, they're not going to do the trick in terms of building a system that's accountable for costs. At the same time, we believe that it's an essential component in order to build systems that are really going to be able to, they're an essential component of, say, an ACO system. You have to have a strong primary care foundation, and they need to be practicing in a way that's integrated and directed towards their patient. And using technology, getting the data, all those things that primary care practices may not have been able to do in the past. So we have a target. Let me explain that. That sounds great. By 2018, poof, 80% of clinicians are going to be in a primary care, in a patient-settled medical home model. It's not just going to happen. The regulations make clear. The affordability standards, by the way, are embodied in a regulation. Referenced, I think at the end is Regulation 2, and I think I know we provided a handout, pre-meeting handout that had the excerpts of the affordability standards, and those are regulations. So the regulations establish carrier obligations, legal obligations to do certain things. Now, that's pretty bald, right? But so what they also say, you have to undertake activities that are necessary to achieve that goal. So it's not, they can't come in, well, I didn't meet my goal, the providers, the doctors, they just don't want to change. Okay, well, that's not enough. You have to explore what avenues you have as a payer to incentivize providers to participate. And explicitly we're talking about, or carriers are talking about, we'll see how that rolls out, both incentives, financial incentives to participate, and maybe a flat rate in terms of increases for those that don't. Payment reform is really at the heart of a lot of the affordability standards. And as I said, ACOs for us are a critical component of payment reform because of the structure that they are contemplated to operate in and the ability to use that structure for cost containment and better quality care. What we've done in the regulation is establish certain population-based contracting targets. Now, by population-based contract, we specifically mean, and it's defined as such, to be an ACO contract. Okay, so we're actually putting into regulation a mandate, if you will, a requirement that carriers increase the number of covered lives that they have, that they're responsible for, that are receiving their care through an accountable care organization. So that's, I think, pretty big. Now, they're obviously, well, that's great, but you're promoting concentrated market power. That's not all the time a good thing. There are some solvency issues. We've built into the regulations an obligation on the carrier to do their due diligence before they enter into a contract with an ACO, that they have reviewed both the financial and the operational capacity of that ACO to accomplish what needs to be done. Nobody wants the provider organization to go under. We are obligating the carrier to do the work that they need to do to make sure that at the outset the organization has the capacity and that they continue to have the capacity. The second big risk, I think, has to do with, you're allowing or promoting market concentration. What are the implications of that? We try to address that through a requirement, or I guess really it's an annual budget cap on the ACO's business. Started out, a little bit mellow, but eventually getting down to a CPI index plus 1.5. A couple of holdovers. Not all healthcare is going to be provided for ACOs, certainly over the short or medium term. We have had for some time a system of requirements around hospital contracting. So this is the sort of the old school type of contract, fee for service. And we have for some time now placed limitations on the annual price increases that can take place in that contract, and keying it towards, again, inflation. And I think at least as important, not only is there the price increase, but at least 50% of the price increase component has to be devoted to quality. So it all having, I think, both a mitigating effect on price increases, as well as trying to push some other beneficial results. We have a couple advisory committees that I think are interesting from the antitrust perspective. There were a couple of issues that we wanted to tackle, but we really knew at the outset we needed to work with stakeholders in order to develop appropriate standards. And the first one was how to increase primary patient-centered medical home participation. And the second is we felt very strongly that there needs to be a shift from fee-for-service to alternative payment mechanisms. Well, how are you going to do that? We contemplated just throwing out some targets, but we thought it would be much more appropriate to have an advisory committee composed of a broad range of stakeholders, carrier stakeholders, providers, hospitals, businesses, consumers, in order to get together to identify what we should do. They are actively supervised. They make recommendations only. Compliance, very important part of this. Progress and challenge. Things are going okay so far. I mean, I think the original affordability standards were established back in 2008, 2009. We've just done a complete revision, and so we're just starting out from the beginning of this year with what we're doing now. So far, so good. Key, I think, is that external actors have been supportive of what we're trying to do. Challenges, what I mentioned before, is the narrow jurisdiction going to be enough to push comprehensive system change? And what I think is really critical there is that we be able to get some buy-in from the other payers and get some alignment around the affordability standards. I think that will greatly increase both the leverage we have in pushing system change, as well as its chances for success. Implications for other states. I mean, I think we have kind of a model here. The Rhode Island model uses existing regulatory levers to hold carriers responsible for affordable health care and imposes system improvement standards on carriers in order to influence hospital and provider behavior. That's a mouthful, but you have to get it in one sentence, right? And we actively, as we said, we're actively supporting the creation of ACOs. So we're kind of all in on that. Although, as I've said, we do have some elements in the regulation that attempt to address some of the risks of ACO development. Particularly, I think what's important is that there are all sorts of different states. Every state is pretty unique in terms of their environment. Certainly, smaller states just don't have the resources of a larger state. It's just a fact of life, and they never will. It's a type of model that, imposing the obligations of carriers who have a heck of a lot more resources than our regulatory agency, we can still try to push towards the same sort of goals. I also think it has implications for states that don't have the same sort of cultural or political environment. Rhode Island is a blue state and proud of it. Doesn't mind active governmental role in society. Let's face it, the other states not so much, right? But I still think the model can be used in those other states if regulators or policymakers, they can try to target the health reform goals that they want to pursue. They don't have to be the goals that Rhode Island is pursuing, but they can be their own goals because, constituents are still important and healthcare costs is a big problem no matter where you are. And they can mold that to something that will fit their political environment. And secondly, we used we have a pretty strong regulatory structure, statutory structure. Not all states do. I mean, they just don't. But every regulator has some leverage. They wouldn't be there unless they had some leverage that they can use with respect to their regulated entities. And you can use that leverage, whether it's licensing, with examination process. There's always something. If you have the will to do it, you can engage in attempts. I wouldn't even call it system reform in those states. I would be, helping your businesses survive, right? Just in general, we have a great team. Commissioner Hittner, a doctor, former hospital administrator, a great spokesman, and by the way, a great client from a lawyer's perspective. That's myself. Sarah and Corey, wonderful, smart, young, apparently don't need to sleep, which is a good thing. And a couple of shout outs to some other folks not here. Chris Kohler, the former commissioner of the office, instrumental in getting this rolling. And I call him the godfather of using health insurance regulation to promote system reform. Second shout out to Michael Bailitt Consulting in Massachusetts, who's been very helpful for us, both in terms of policy development, as well as now that we're into the implementation weeds, he's helping us getting this stuff done. Just a few documents that might be helpful. Thank you.
I wanted to start by first acknowledging the Petris Center. You are really at the right place at the right time with a focus on consumer protection and consumer interest. I think the consumer has been left out too long, and with high deductible health insurance becoming the norm, I think being interested in consumers is going to be key, because it's no longer going to be hospitals interacting with these big payers, with employers in the background. It's going to be providers interacting with real people day to day for the first $3,000 or $5,000 or $10,000 of expenditure. So getting this right is important, and I think competitiveness, there's not enough of us thinking about that or focusing on it, and competitiveness is key for a consumer-facing health system. I think, of course, I'm an economist like Richard, so maybe I'm biased, but anyway, I think this is, really give you credit. I think the report you guys put together, I don't know if it was for this conference or at the same time, but it's just an excellent report and really is useful. Also, I want to say that New York, I should say, has a lot of Massachusetts and Rhode Island envy, so in some ways we'll build on some of the things they said. Maybe we should have Texas envy too, but we don't know as much about Texas, And finally, before I get started, I want to acknowledge Greg Burke from the United Hospital Fund, who is a important grantee of ours at the New York State Health Foundation, and really has done a lot of work on ACOs and just all the system change that is going on. And I think he'll be a great addition to tell us what we all said wrong. He'll probably mostly say what I said wrong because he knows New York best. But anyway, I want to acknowledge Greg's work in this area. Okay, so like others, let me start out by saying, let's see if I can get the right thing, that ACOs are part of this bigger context of a swirling set of changes going on. But I thought it would be useful to just understand the New York context real quickly just before, because I think that influences things a lot. The first thing about New York is we are very expensive, very high healthcare costs way up here at the top. Like California, of course, is way down there somewhere below the median, but we are very expensive healthcare. So obviously we care about all of this, and it's seen as just a real burden. Of course, I will say that part of the reason we're expensive is we've done very well with federal money for graduate medical education and other things. We've been very politically clever, I think, and that's one of the things. So the other thing is we have a very large Medicaid program. We're very committed to services for low-income people. I guess we're a blue state too, probably as blue as they get, and so there's a lot of that. And so if you look at Medicaid, we spend more per capita, except for Connecticut and D.C. Or this is per enrollee. We also spend lots more per capita. Again, California is way down there somehow or another. And so again, all of this sort of value-based payment is important to us because we're spending a lot of money. Also, per capita Medicaid is very high. I always think this slide is important because part of the reason we're so expensive with Medicaid is because we are very generous with long-term care, nursing homes, home care. We're very generous with spending money on the disabled. So those two populations really are an important part of our cost structure. It's not that we're just totally inefficient. We sort of provide a lot more services. So just in terms of context, downstate, New York City is dominated by 5 large academic health centers who rule the world. And they are both important from a scale point of view. They're important from a political point of view. They're powerful as individual units, and they're very powerful as a combined unit represented by the Greater New York Hospital Association. But there are lots of payers downstate also. There are very fragmented payers downstate. Upstate is very different. The Rochester, Albany, Buffalo part of the states, and then the rural parts of our state, which are around the Pennsylvania border, what we call the southern tier, and the Adirondacks up in the north, where we are very rural state. And upstate has a lot of active pockets of regional planning. Rochester, which has always been into regional planning, is doing things very collaboratively. The Mid-Hudson Valley, the area between Westchester and Albany, has a lot of collaborative activities around information sharing and things like that. And the Adirondacks, which has had a hard time as a rural area, has had a lot of leadership from community health centers and has gotten their act together to have almost like a combined single payer system where everybody cooperates together. So there's some interesting things going on upstate. Rochester is a typical market, though. It has 2 major health systems. One led by University of Rochester, and sort of then it's against everybody else, which is sort of revolves around what was the Rochester Public Hospital. But anyway, so you only have 2 systems that are really competing, and you really have Excellus, which is the Blue Cross plan, has like 80% of the market, and one other insurer. So there's very few payers and very few provider systems. So there's really competitiveness issues everywhere except New York City, and just that's how it is. And then finally, we are a very hospital-centric state, weaker primary care systems, but we're also a state like Massachusetts with a long history of regulation that we're proud of. And so there's a lot of instinct to regulate, so that's out there. So that's where we start. Now, I think it's important to realize that there really are these dynamics at play, that an ACO is just part of it, as people have been saying. I mean, first of all, the dynamic is everybody's decided fee-for-service doesn't work, both payers and providers. And it's obvious for payers it doesn't create the right incentives, but providers realize fee-for-service doesn't work because it's too easy to cut it. It's just too easy to just, cut, and you can't, unless you're Amazon, you can't make money by losing money on every transaction. And I'm not sure how they do it, but the fact that they're willing to send me 4 batteries for no shipping cost is beyond me. But in healthcare in New York, Medicare and Medicaid are very big payers, so they can do whatever they want, and the hospitals sort of have to take it, and so that's why they realize that fee-for-service isn't working for them. So, okay, so given that there are really 4 things, I think, happening in New York. One is Medicare ACOs, which is sort of one thing we're really talking about today. The second is what I would call the Wild West. It's just all sorts of things going on there in terms of contracting and bundling and sort of payers interacting with providers. Like I'll do the special thing for your diabetes patients. I'll do a special thing for those. And so and that's sort of like it's all value-based payment and it's all about risk. But it surely doesn't seem like an ACO. It doesn't seem like an integrated care. Sometimes it's happening without any integration, but it's just people are doing it. It's like we have to remember that there's this whole underplay of this formal stuff that we're regulating out there that might be more important than anything. And then the other, besides Medicare ACOs in the Wild West, in New York we have the government, right? And the government, the state government has this huge set of activities I'll describe in a second around money that is flowed in from the accountable of the Affordable Care Act. And then we also have the typical department, we call it the Department of Financial Services, which is the insurance regulatory agency, and the State Department of Health, which does other regulatory stuff, very similar to what we heard like in Texas and Massachusetts and I guess Rhode Island. You didn't talk about the Department of Health really, but okay. So that's where we start off. Let's see. So now I'll go this way. I want to say just where we are. We just released this payment report card. Our foundation did that. The Catalyst for Health. Catalyst for Payment Reform, a California-based organization, right? And they did it, and I think California Healthcare Foundation has done the same exact thing for California. We also have California Healthcare Foundation, Envy, in New York, so we learn a lot from them. And so we did this sort of looking at it. And New York is interesting. You can't read the visuals, they're too complicated. But the basic stuff says that we have a system where 94% of commercial payments are still fee-for-service. Medicaid, it's less than that. 34% of those payments have some tie to value, sort of quality incentives and others. 33% on the Medicaid side. 15% involves some performance-based financial risk. Interestingly, Medicaid, where we're almost virtually completely managed care at this point, 46% involve financial risk, and just 3% in the commercial side and 13% in the Medicaid side have actual shared risk. So I'd say it's happening in New York, but we're probably nowhere near, I think, as much as in California and in some other states. The state government is committed to having 80% of all payments be value-based by the year 2020. So we'll see if we get there, but there's surely that impetus to do it. We will keep measuring them at least. So let's talk about ACOs. And again, some of this is based on Greg's work, but we have, I guess, I keep getting different counts, but I guess we have 26 ACOs, right? I thought 27, but this adds up to 26, but somehow or another. So shifting. They keep cropping up. So we have 27 ACOs in New York that are Medicare ACOs, right? The traditional thing out there. They're really diverse, and you can see they're growing. Nowhere near as much as California yet, but they're really growing. We have 8 of them in what we call upstate, above Albany and west of Albany. We have 4 of them in the Hudson Valley, that is between Albany and New York, 5 of them on Long Island, and 9 of them in New York City in the 5 boroughs. So they're all around, and they're pretty diverse in terms of sponsorship. Both, there's a blend of hospital-based and really the 4 categories of hospital-based, and then physician hospital partners, and then provider group practice ones, and then the provider network ones. And they're pretty evenly dispersed across those. Although the physician networks and the physician hospital partners are the biggest majority, and those are the least organized, the least integrated, if you will. So there's, that's how it is. So that's the ACOs growing. They're all over the place, and they're doing pretty well. And I really recommend Greg's 2 reports that really lay out some of the details on our website, on the United Hospital Fund website. So I'll let you do that. But the other big dynamic in New York is the $6.3 billion that the state received for a DSRIP program, like the Medicaid waiver program, and that's thank you, and that's just really dominating the discussions in New York and the activities in New York. Everybody's out there doing it. And the idea of the DSRIP program, it has these goals and metrics. It's about system transformation, trying to create integrated care networks, and is about, has some specific goals on clinical and population health improvements, and specific goals on reducing unnecessary hospital use. And of course, the way these Medicaid waivers work now, if you don't achieve these metrics, you don't get the money. So it's all supposedly serious. I don't know who they get to actually say whether you achieve the metrics, but but actually there's a huge expensive evaluation. And what the state has done is they're basically creating these 25 what we're calling performing provider systems, PPSs, all across the state that are like ACOs, I guess, although there's a huge emphasis on integration. So they involve, you have to have behavioral health, you have to have mental health, you have to have, you name it, you have to have it, home health care, and you have to have a very large network. So these have gotten to be very cumbersome networks of providers that are contracting together to form these performing provider systems out there, and that's there's a lot of money floating and a lot of energy and activity. It's really good to be a consultant right now in New York to help put these things together. The expectation is that these 25 PPSs, remember this is really Medicaid to start with, so it's Medicaid money we're talking about, but that's big enough in New York to drive change, that these will become ACO type organizations, and this is how the state will drive towards 80% value payment. So it sounds just like Massachusetts and Rhode Island, and I think California of the same system. We all think alike across the country. And the hope is that it will also spread to commercial payers, that it will move there. And in fact, the state has a second grant from the federal government, $100 million for what they call the State Health Innovation Plan. And this money is going to be used specifically to drive value-based payment reform and to drive advanced primary care. So the state is developing, you have to think about NCQA having the various elements of primary care medical homes. What the state wants to do is create a level 4, I guess, would be like, that would be more focused on outcome performance and stuff like that, and they would pay extra Medicaid money for that. So this $100 million is also going to work on that, and it's not just within those 25 PPSs, but surely they'll be taken care of. Now, I should have said about the PPSs, with those, 23 of those are hospital-based or hospital-led organizations. Only one is a physician-led organization, and one is an FQHC-led organization. So these are very hospital-centric, and it goes to again, where the power is in our state is with the hospital. So that's how it's worked. They have to have physician practices, obviously, as part of their PPSs, but just who the money is flowing through is interesting. So. As I said, there's a Wild West out there besides Medicare ACOs and then the Medicaid PPSs. There's variants of risk-based payments all over the place. 2 hospital systems in New York, North Shore LIJ and Montefiore, have created their own health insurance companies and are trying to contract directly with providers. And there's others who are talking about doing that. There is some direct contracting going on between businesses and providers. And then there's all the disruptive innovation of the retail clinics and some of these primary care organizations that for $89 a month will do all your primary care with boutique-y stuff and blah, 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 and stuff like that. So there's all out there. Okay, so let me get to the regulatory part, though, of what happens here. Is regulation, like in most of those states, it's partly the Department of Financial Services, which really does the commercial regulation, worries about people who take risk, that they have reserves and so on. And then the Department of Health does all else and always has done some certificate of need and is very actively engaged. There are 2 things that are going on here. I think on the insurance regulation from the Department of Financial Services side, they have developed lots of guidelines and lots of regulatory infrastructure about what happens when a provider takes real downside risk, or if they contract directly with a payer, and it's a typical type of things where where the provider has to have some reserves, and the health insurance company has to have some responsibility tied in. So that's the one part of it. The second part, though, is in the Department of Health. They have developed a program very much like what was described in Massachusetts, a voluntary ACO certification program. It has the same list of criteria almost that Massachusetts or Texas described in terms of all the assurances you have to give. Interestingly, the quid pro quo, and I think that's true in these other states, is the presumption that you get some sort of antitrust assurances that you're not doing anything wrong. But in New York, there's this interesting, and they were referred to earlier, interesting set of letters. Actually, 3 of our preferred provider systems, or whatever they are, performing provider systems, or anyway, they wrote a letter to the FTC saying, we're nervous about all this. We sort of, we're being told that we don't have to worry about it because we're being efficient collaborations that won't affect competition, but we are worried that we are going to affect competition and that we are going to act monopolistic at times. It was an interesting letter in a sense saying, and so we think we need, and the state's telling us not to worry about it, and we want you to tell us not to worry about it. And the FTC wrote back and said, sorry, you have to worry about it, and so it's sort of this stalemate in some ways. And of course, as was laid out in the Texas presentation, it's very clear that if you're just having collaboration to improve efficiency but not affecting competition, it's okay. But otherwise, you have to worry about it. And so I think New York and all of us are left in that gray area of exactly how do we balance those two. And to me, it's just a crucial element of what comes out of all this. Is in New York, we talk mostly about integration and less about competition, but in the end, I think it's both. Thank you.
I'm Ann Hollingshead. I'm a Master of Public Policy candidate at the Goldman School of Public Policy for the next 1 week, 3 days, and 4 hours. And I had the great pleasure to work on this report with Richard and Brent on state actions to promote what we call the responsible development of commercial accountable care organizations. So in some ways, actually, this is going to be a bit of an overview or a framework for what the other panelists have already talked about. And then I'm going to get into California, actually, sort of at the end. Okay, so getting into it. Our policy motivation was we were interested in looking at what tools state regulators are currently using in order to promote responsible development of ACOs. So what does that mean? That means we're looking at comparing the potential benefits of ACOs and hopefully promoting those to some extent, and balancing them against the potential risks of ACOs, right? We want to hopefully have a set of tools that allow us to do that. And we were interested in commercial ACOs specifically because there's been actually quite a lot written on using the state's role as a payer in order to push healthcare reform or to promote development in this area. But there's been very little written about the commercial side. And actually there's been a lot of state action on the commercial side. You can see that, from the presentations before me. So we were really interested in catching up the literature a little bit with what's actually happening on the ground. So I'm just going to give you a brief overview of our study. We started by identifying 12 potential case study states based on conversations with experts, and we narrowed those down to 4 and also invited them to the conference. So you've already heard from them, but of course they're New York, Massachusetts, Rhode Island, and Texas. And we spoke with regulators in each state. In some cases, I spoke with people who have already spoken on this panel and other top regulators that were directly involved. And then from these interviews, we identified 6 key policy goals, and I'm going to walk you through those 6 goals in a minute. But I think that those goals can provide something of a framework for understanding how all these different regulations in different states fit together, right? Like, how can we think about their relationship with each other? So those are the regulatory tools that achieve the goals, and I'm going to walk you through them in basically a matrix form. So we'll start with the goals. The first is to support and encourage integrated care. Everyone understands why that's important for the development of ACOs. And at a state level, there are some barriers to integration. This has, of course, come up in the panelists before me, but these can include state antitrust laws or, for example, bans on corporate practice of medicine. Second, support alternative payment methodologies. Again, very important for the development of ACOs. And again, there's some state barriers. We could discuss, just how much these really do form a barrier to APMs or not. But these can exist through fee-splitting laws, for example, anti-kickback laws. And states may think that they have an incentive to remove these barriers in order to encourage the adoption of APMs. Again, primary care is very important. This is definitely a focus in Rhode Island, as you heard from Herb. And the role for the state is perhaps less clear in this area, but we may envision that there is a role for the state to promote primary care. Okay, so this now gets over to the risk side. And of course, associated with integration can be anti-competitive behavior. And of course, again, attorney general's offices have a role to play in protecting the public from anti-competitive behavior, as I'm sure Kathleen would be able to tell you. But on the other hand, AG's offices often don't want to use litigation as a full substitute for regulation. So states may have a role to preemptively protect the public from anti-competitive behavior using some kinds of regulatory tools. So then again, another risk of ACOs is that providers are assuming a lot of risk. And this can, of course, present solvency concerns. In some cases, under global payments, ACOs can be taking on as much risk as a traditional payer would. And so states may have a role in regulating solvency in the same way that they might think about regulating solvency in the insurance market. And then finally, develop and support comprehensive databases. So again, health infrastructure, IT infrastructure is very important for ACOs to meet cost and quality benchmarks. And because of economies of scale, there may be a role for the state to play to fund IT services, for example, EMRs or claims-based data. They could do this directly, or they could do it indirectly through a private infrastructure bank. So those are our 6 goals. And now I'm going to talk about the tools that regulators are using to promote these goals. So to some extent, this is going to rehash what other people have already said, but hopefully maybe lay it out in a more systematic and overview way. So the first set are tools that support and regulate providers. And we have risk certificates, which specifically come from Massachusetts. And to some extent, something similar, Jim already talked about, has been happening in New York with Regulation 164. But essentially, risk certificates are issued on a mandatory basis for risk-bearing provider organizations. And from our conversations with DOI, what they said was that they see this as a supportive capacity. They see this as an opportunity to talk with providers, particularly small providers or rural providers, that maybe don't have a strong understanding of the solvency implications associated with taking on a lot of risk, and working with them to help them understand those implications and make sure that they're prepared to take it on. Certificates of authority. So I'm actually going to get into this in a little bit more detail towards the end, because they are something that's happening in 3 different states, as you've already heard: Texas, New York, and Massachusetts. And they can take on very different flavors, very different objectives. And as such, we think that they can be a pretty interesting, adaptable, flexible tool for states to use in order to meet a variety of goals. So legal exemptions, these can be coupled with a certificate of authority in many cases. They can also be provided in theory in a blanket fashion. So this would be something like an antitrust safe harbor or safety zone, which in some cases is coupled with a certificate of authority. And then it can be an exemption on the ban of corporate practice of medicines, fee-splitting laws, and anti-kickback laws. And then finally, support and funding. So this is something that we found is happening more on a theoretical level than necessarily really being implemented in a comprehensive way in a lot of states, but we still think it's really an interesting role that the state could potentially play. And this would include things like, funding databases, as we talked about earlier, or, you could see a role for technical assistance, for example, in helping providers understand risk management, for example. So then the second set of tools are those that support and regulate payers. And Herb has already talked about these very extensively for the case of Rhode Island. So I'm going to just kind of gloss over them a little bit. But I wanted to at least give you a sense of where they fit in our thinking in the overall structure. So the first were a set of cost caps and benchmarks. Herb talked about these in a lot of detail. But these are hospital price increase limitations, for example, or ACO budget increase limitations. And then the second are a variety of state targets. And my understanding, and Herb can correct me if I'm wrong, but cost caps and benchmarks are binding and, of course, regulated through the rate review process. The state targets, for example, population-based contracting targets, primary care targets, et cetera, these are not binding, but rather the insurer has to demonstrate a willingness and ability in a schedule to meet these targets over time. Okay, so here's where we are in terms of state activity. This is not necessarily meant to be completely comprehensive of all the roles that states are playing, but rather illustrative in terms of what we found. And as you can see, of course, on the right side, as Herb, I think, said, Rhode Island is pushing healthcare reform using its existing role as a insurance regulator, which I thought was a really interesting way to push it. And then on the right side, we have mostly activity by New York, Rhode Island, Texas, and Massachusetts. So I'm going to focus just for a second on risk certificates and certificates of authority, because these are very interesting to us. So you have 3 states that are doing these, and Massachusetts has, you can sort of put the risk certificates in the same bucket, although it's a different animal. But so Massachusetts has its ACO certification and risk certificates, and then Texas and New York have their own certification processes. These can be either voluntary or mandatory. They can create a safe harbor or a safety zone. This is, of course, a big focus in the Texas certification process. They can provide exemptions to other laws and requirements. So this is something that's done in New York. They provide exemptions to the fee splitting, ban on corporate practice of medicine, and anti-kickback laws if you receive the certification. It can include a solvency review, another big focus of the Texas certification process. It can include quality reporting. This is something that's still under development in Massachusetts, but is an eventual goal of the certification process. And then in New York's case, so when the organization submits their certification, after DOH approves it, that organization will continue to submit data to DOH on an annual basis that then DOH will publish on its website publicly. So we thought that was a pretty interesting quality reporting metric in New York. And then it can include a recertification requirement. Okay, so I'm just going to briefly talk about what we're thinking in terms of where we want to go with this research. So California has, as many of you probably know, a really long history, a very successful history of managed care. And we also have a lot of ACOs in the state, and they're growing really rapidly. From just 3 years ago, we had 30 ACOs, and today we have 100. So it's quite an amazing growth rate. And California's ACOs face many of the same regulatory challenges and regulatory barriers that we see in other states, but we don't have this regulatory context in California like we have in these other states. So we think that there's perhaps a really good opportunity for us to take some lessons learned and apply them to California. So that will be the topic of a report that we will publish this summer. And finally, I just wanted to say before I sign off that everything that I presented here is a part of a preliminary draft report that we're still in the process of working out. You received a copy of it in the materials that Katie sent to you on Friday, and I would be happy to take any comments so that we can continue to improve it. And if you want to talk, now, or obviously we could also talk offline. So thank you very much.
First of all, it's an honor to be here among folks that are actually pushing the envelope and doing this stuff in so many states so effectively. And did such a good job at summarizing the presentations. Frankly, it's a little embarrassing to try and follow her on this, but I want to do three things. One of which is, I think we've got a definition of terms issue that I'd like to probe a little bit. And second, I think I'd like to, because I've been playing in this field a little bit, I'd like to give you one of the provider perspectives on ACOs as I've seen it in New York from a provider standpoint. And then third, go through a couple of the pieces, hopefully not reiterating too much of what Ann said, about what I picked up from the three panelists. So, okay, so first some definitions. New term, aggregophobia, an extreme or irrational fear of aggregations, particularly in the healthcare sector. That's one of the themes that I'm picking up in a lot of the discussion. It's actually schizophrenic aggregophobia because we can't really decide if we like it or hate it. We love it when it's an integrated delivery system and it operates in the public's interest, and we hate it when it's restraint of trade and price fixing. Either way, I would argue ACOs aren't the problem. The aggregation of providers is happening, but when they organize as ACOs, they are organizing and contracting with payers for specific deliverables. It's not about increasing costs. Working against a budget is what they're doing, and is managing against the total costs of care. And that's, I think, one of the key pieces, actually two key pieces in here. Their contracts define ACOs, not the organizations themselves. You do an accountable care contract, and the contracts, if they are an ACO in the way that we're talking about it, they relate to total costs of care, which is, I think, a different thing than getting whacked on increasing fees. The second is integrated delivery systems, just to sort of like get a clear definition of this out there. You may recognize this definition. It is a network of organizations providing or arranging to provide a coordinated continuum of care to a defined population willing to be held clinically and fiscally accountable for the outcomes and health status of the population served. Stephen Shortell, 1996. This is the definition that people have absconded with and turned into the definition of an ACO. And I would say that an ACO is an IDS that does a shared savings, shared risk, or capitated contract. The organization of the providers is the key, because they have to organize themselves to perform. But it's the contract that makes it an ACO. So quick hit on the organizational types. I think there are big differences within the genus ACO down to at least 4 and probably a number of other species. There's the physician-led ones, tightly bound, loosely bound, and the hospital-led, tightly and loosely bound. There are representations of all 4 of these in our ACOs in New York State, and the ones that are probably best positioned are the ones up top in the yellow, because they have a whole series of functions, and I think one of the biggest is common culture, that they actually have a sense of usness. There's a sort of a bond that is either organization or cultural in ways that allows physicians to call each other out around the care of patients and what they're doing. Going back up a second, primary specialty behavioral health services, and to an extent urgent and ED services, that's where the action is in the ACOs. It's not in hospitals. It's not really in the post-acute side. If you can manage population health in the ambulatory care sector, then you've got an ACO that works, which is why the groups, the top left box here, are probably the best positioned of all in terms of where you're going with ACOs and what you're going to be able to do. Shared savings. To date, we have not seen a lot of shared savings. This is, if you remember Mickey and the Beanstalk, this is the scene where they dumped out the can of peas, one pea came out and they sliced it up. This is where shared savings are in the state of New York, where 3 institutions actually shared in any savings. Another 5 got close but didn't get there, and the remainder lost varying amounts, with one losing a rather stupendous amount against benchmark. This is funny because the ACO program in Medicare is you against you over time in terms of the benchmarking. So therefore, you're competing with your own behavior last year, which makes it awfully difficult for you to make money if you were efficient. If you were inefficient, you have a somewhat easier task of it, and that's part of the mechanical issues that are driving ACOs. Last point on, well, actually 2 last points. Accountable care is a zero-sum game. The savings you generate are from reductions in hospital income. Reductions in preventable hospital admissions and readmissions are the first 2 targets people are going after to generate savings in ACOs, and they're taking that money, actually they're investing it ahead of the curve in the shared savings program, in delivery system infrastructure for population health, including claims management and analysis, care management programs and services, and they're investing it in primary care because, as has been noted a couple of times, if you don't have a front door that works, you ought not to be in the population health business. And that's what primary care in the medical home model does. So this is, I think, where the physician-led group practices are looking at ACOs. The Maasai in Africa keep cattle, and they milk them, and they use that as a nutrition source, and periodically they'll bleed them and pull out the blood, mix it with the milk, and drink it. This is the hospital. The incentive here is to keep the hospital alive long enough and well enough so you can keep bleeding it for the reductions in cost for hospital utilization in order to be able to feed that money back into the physician side. And the next target here, once they get done with the hospitals, is going to be looking at specialty care overuse. This is a place where the groups really have an advantage because they can call each other out on these things and they can begin to manage some of these issues as opposed to getting into full and complete tribal warfare. This is the opening gambit, which is the specialty calling out their own overutilization, but it's seriously the next, once you squeeze out as much as you can from the hospital, this is the next obvious target. So takeaways from today's discussion. First, everybody is on the same goal. Delivery system reform to make the system work better and payment system reform to make that work. Looking at ACOs, some, and the need to identify them, to analyze them, to track them, follow them standards. One of the things that Massachusetts is doing, which is breathtaking, is looking at provider organizations of various types and requiring some degree of accountability, reporting in of what they're doing. A lot of this action is happening under the surface of the water. You can't see it. And that's particularly true of the commercial ACOs. We don't really know what's going on there. And I think accountability and standards for quality, for data and that describes what they're doing around quality, cost, and reporting that in some consistent fashion, I think that's a really, really big issue for a lot of the states, and I think that's something that we need to focus on. How do we, in fact, out these entities in some serious way and look at them? Fourth big issue is the levers that are used. Here's some of the differences that I think you can come at it from the regulatory side on insurance, from the regulatory side on the Department of Health, or from some of the attorneys general looking at competition and regulation and how that can be anti-competitive. I think the state action immunity issue is actually intriguing. As Jim noted, it's sort of interesting that they began to question whether state action immunity really is a protection, or whether, as they said in their letter to New York, look, if you're doing things which are pro-competitive and justifiable on their own, then you don't need state action immunity. And if you have state action immunity and you are doing things which do not pass that test, we're coming after you. That begins to add a dimension to that question for me, that there's a lot of work involved in undergoing state action immunity. And I think the ACO regulations in New York really did take a large step in that direction, that if you get a certificate of public advantage, that somehow you've got the lamb's blood painted over your door jamb so that the angel of regulatory death passes over. And it's not clear that that's being recognized or honored or will be in the future. I'm not against, and I think there's a theme here, not against aggregation of providers, particularly across levels of care. Physicians organizing together, I think, is a great leap forward. Physicians organizing and managing care across the delivery system with hospitals is a next-gen move. And doing that in the context of a shared savings or shared risk or capitation arrangement that focuses on total cost of care ought not to be a competitive issue. I mean, if you are reducing total cost of care, if you're capping and reducing total cost of care, does that in fact do a lot of the stuff that you want it to do with your competitive market? So that's some of the takeaways that I picked up on from this. And I think we need, coming back to the first point, I think we need to get a lot clearer about talking about ACOs, because it's a pretty mushy term right now. And a lot of people say they're doing ACOs when it's gussied up pay for performance of one sort or another. We need to define what is an IDS and how are we going to regulate that. And I think that's one of the things that Massachusetts is probably in advance of the rest of us states on. And we need to figure out a way to look at these deals in ways that protects the public's health and ensures accountability and can protect the public's purse and that of the payers and the upstream purchasers of care. I'm not sure that the insurance regulations, particularly with the blind spots that you have on the self-insured, over whom you have virtually no oversight, enable you to do that as effectively as you might. And for me, that's the biggest challenge. ACOs are deals, and you need to figure out how to get them out in the open and look at them in some organized fashion. Thank you.
So hi, I'm Brent Fulton, and wonderful panel. I guess I had a question for Rhode Island. I've done research in trying, you have insurers out there that typically have a lot of churn in their underlying population, that a typical enrollee, it's employer-based, every 3 years there's a lot of churn, so they don't have a great incentive to invest in long-term health. And I was very intrigued by Rhode Island's stance, trying to invest not just in reducing health during the insurance contract that lasts 1 year, but long-term. So the incentives that you're trying to set up, is that what's driving that, the long-term health and primary care, trying to have 11% global budgets and so forth? And I was wondering how you came up with those figures. Why 11% in primary care? The global budgeting, is the global budgeting that you're trying to get to, is that a 1 year, or are you trying to have them do global budgeting over 5 years and track people that have left insurance plans?
Sure. Does that work? Yeah, okay. Two different, I think, issues. In terms of primary care, we did a benchmarking study back in 2009 or so that tried to take a snapshot comparison between what Rhode Island carriers were spending on primary care versus other, quote, high-performing, systems. And we were just out of whack. And so the original requirement, you got to increase that by 1% every year. We got to a point now where the allocation was reasonably high. It was at a certain range, and people were saying, are you sure we need to increase it 1% every year? So what we did was just to fix it at where we were, and we're committed to doing another study, re-benchmark basically, and see if that's the appropriate number. In terms of the, what was the, I'm sorry.
The shared savings, you want to get
Yeah.
percent up to having a shared savings contract.
Yeah, and how do we get the?
1-year contract, or are you looking multiple?
Oh, they're usually multiple-year contracts. They do get renegotiated, typically every 3 years or so. Again, we started from the norm of where we're at now. Actually, we pushed the norm a little bit in terms of where people are at in terms of population-based contracting. Took that, pushed it a little bit, and then increasing it every year.
Mary Beth?
So actually, to follow up on Greg's comment about the fact that they're very ill-defined. Oh, I'm sorry. I'm Mary Beth Shannon with California Healthcare Foundation. Thank you, Joe. The definition thing I'm struggling with in each of the different states. I'm wondering if we do a kind of a quick lightning round of like what's the key element that makes it an ACO in your view? So perhaps in New York, it's because it's a PPS and it's been sort of certified as that, but then you also have other ACOs floating all over the place, either Medicare or commercial, I assume. What is the secret element in each state?
I just want to tag on to that.
You are.
That was my, oh, sorry. Touche. I am Jill Yegian with the Integrated Healthcare Association, and I had a really similar question, and I want to tag on to it instead of repeating it, which is that we have found something really similar to what Greg mentioned, that there really is around the contract more than around an organizational structure. And so do you agree with that or do you not? Which is a subset of Mary Beth's question about what it is that the thing is that you're organizing your regulation around.
All right, who wants to start on that? Massachusetts. It gives us Massachusetts a good start, right?
Sure. So we're obviously in the process of developing our ACO regulations, so it's a little bit premature for us to kind of be saying exactly what we envision an ACO to be. But at a high level, we view ACOs as having features across kind of 5 core dimensions, and that's likely to be how our regulations will develop. And so those are around care delivery. Those are around having certain defined analytics around performance improvement that are being passed along to clinicians. It's around having certain types of financial incentives, alternative payment methodologies, and kind of an internal funds flow so that you're actually passing those incentives down to the clinicians who are actually providing care. It's about having certain clinical data capabilities. And about having certain methods in place for patient and family engagement. And so those are really how we've been thinking about it. In terms of the actual standards that we're likely to define, we are looking to build off of those standards that are already being used by CMS and by commercial carriers in Massachusetts. And simultaneously, we are also very interested in and have been actively promoting the uptake in alternative payment methodologies. And so the two are very closely intertwined.
But is the first step that a group self-identifies, we are an ACO, we have these elements, and they come to you, versus you looking across at the organizations in the state and saying, wait a minute, those guys didn't come to us and apply for certification, but they look an awful lot like what we would call an ACO?
It's a fantastic question. Since we have a voluntary program, we're not envisioning going after people and asking them to certify. It's really a process for us to be able to get information about the evolving marketplace. And so we're looking primarily for entities that are identifying themselves as ACOs, either through commercial contracts or through public payer contracting. I should note that our Medicaid program in the state, Mass Health, is in the process of developing an ACO. We're kind of working hand in hand with them. where we are likely to be kind of defining the types of capabilities that will be part of that, and then they're going to be defining the payment structure that goes along with it. And so again, just kind of reinforcing that the payment and the organizational structures are very, very closely intertwined.
But I think the answer from what you're saying is it's the contract
Right.
that makes it an ACO or not an ACO. Whereas in Texas, it's the certification or
I mean, this is
or a combination of things.
the hardest question in some ways. In Texas, I think, so I like the way that Greg laid it out. You have to have the integrated delivery system in order to engage in that kind of contracting and hope to be successful at it. And I think in Texas, the healthcare collaborative regulation is really about state action immunity. So at the point where you have a group of affiliated providers who are not one economic entity, but that are engaging in contract negotiations, they're trying to sell this as a new product, this integrated care that we're offering to sell to you for under these terms. I think that's where it becomes an ACO.
Okay. And in New York?
Yeah, I'll go next. I think it's pretty clear in New York. These PPSs, are the Medicaid creatures, are integrated delivery systems. I almost forgot that article. And so they're not formally talking about risk-based payment with those 25 PPSs. It's about integrated care. So I think that's distinct from taking some risk for a population. And our foundation, before all this started, made a number of grants to organizations to do what it turns out is like ACO stuff, but never used the word, never thought of the word. But I remember our first one was to an FQHC that wanted to take risk from a commercial payer for their diabetes patients and some other folks and say, you're paying us so little, we'd rather just capitate. They had no idea. They didn't have any relationship with the hospitals where those folks were going or the specialists they were going, but they just felt that they could figure out how to cut costs for those patients. So turns out it was a lot harder than they thought because they didn't have relationships. But anyway, I would call that first grant we made in this area to be what we call accountable care. It was a contract, risk-based population, but it didn't necessarily have integration in any formal way.
Rhode Island regulates the contract, the population-based contract, not the entity. The definition of integrated system of care, or ACO, in the regulation is really quite general. The definition of a population-based contract is very specific, and that's what we key our targets and our requirements for carriers.
Anne?
Well, I can. Yeah, I'm California now.
Sorry, yeah.
Okay, okay. But I'll say, given that California doesn't have any ACO-specific regulations, I think it's probably a lot less clearly defined in this state.
So, if anything, it's maybe the contract, but for lack of anything else.
Okay.
I suppose, is that?
Just for clarity, the contract between whom and whom?
In Rhode Island, it's a contract between the commercial payer and this entity that assumes responsibility for the total cost of care of patients.
Okay. Okay, yeah, one more, and I think then we'll take our break.
I'll be quick. A given provider in New York anyway, has contracts with multiple payers. I call it the 7-layer cake. So you do an accountable care deal with one payer, you still got 6 that are paying you old-time religion. At what point does it make sense for you to flip your entire production process to align with the lower cost, higher quality behaviors that an accountable care organization has? But each of those deals is, this payer has these covered lives doing a deal with you as a provider group, and you're responsible for that particular group of people, not for the other 7 or the other 6. And I think that's part of the weirdness of this, is it really does end up being one layer of a cake at a time.
Okay. I think we're done. I will just mention from this is this interesting dialogue of healthcare people and insurance people and antitrust lawyers. The history, of course, has been that when providers have gotten together to negotiate contracts, they run into an antitrust problem because it's price fixing. And so a lot of the, certainly as many of us have seen, the response to that has been to merge. And so there's a long tradition now of merger in order to develop more bargaining power without really anything else going on in terms of integration and so on. So, you know, antitrust enforcers have been watching like hawks for a long time, and this was always the underlying concern about ACOs, that this is just another rationale for merging so as to increase costs. And anyway, the state action aspect does obviously make a difference, and the regulatory apparatus is extremely important potentially for doing a lot of good things. For those of you who are just kind of encountering the whole state action notion, essentially you can get immunity, but you got to submit to regulation if you have it. There just isn't any in between. There is no kind of what do you call it? I guess carte blanche, where you're not regulated and you're not subject to the antitrust laws. It's pretty simple, but it's really no different from any other industry at all. Anyway, thank you all. We'll take a little break for what? We got a 5-minute break and then we start? Yeah?
So thank you again to our panelists.